Welcome to UPSC Vinoth. So today we are going to discuss polity current affairs for prelims 2026. Earlier we was making video on each and every topic, but due to time constraint, I'm going to continue with the series of topics discussion in a single video itself. So let us start. So first, reservation of SC, ST and OBCs in private educational institution. See, with respect to 93rd Amendment Act, the Congress party has demanded legislation to ensure reservation for scheduled caste and scheduled tribes. See, Congress party, why it is in the news? See, this reservation for SC, STs and OBCs in the news due to the Congress party has demanded the legislation to ensure reservation for scheduled caste and scheduled tribes and OBCs in private education institution, and that too private non-minority. So this makes the context with prelims 2026. So let us start with constitutional provisions. So constitutional provisions, Article 15, Clause 5, Article 19, Clause 1, Subclause G, talks about the reservation with respect to SC, STs and OBCs in private educational non-minorities institution. Non-minority. Here the key word is non-minority. So let us talk about Article 15, Clause 5. So Article 15, Clause 5 empowers the state to make special provision reservation for SC, STs and OBC advancement. See, you can make special provisions for reservations for SC, STs and OBC's advancement. So this is Article 15, Clause 5. So and then Article 19, Clause 1, Subclause G takes right to practice profession and right to practice profession on its own, any occupation, trade, business. So, however, Article 19, Clause 1, Subclause G is subjected to reasonable restrictions. Okay, now Article 15, Clause 5 overrides Article 19, Clause 1 because by giving reservation, so you are denying the autonomy of Article 19, Clause 1, Subclause G. So this makes the unique constitution framework because Article 15, Clause G, 15, Clause 5 gives special provisions for reservation. At the same time, Article 19, Clause 1 right to practice. See, Article 19, Clause 1 gives right to practice any profession or to carry any occupation or business. However, it is subject to reasonable restriction. Article 15, Clause 5 explicitly overrides Article 19, Clause 1 to allow reservation in educational institution. To allow reservation in educational institution. This makes the contradictory statement. This makes the contradiction between Article 15, Clause 5 and Article 19, Clause 1. See, this everyone knows. This thing everyone knows. So, for with respect to this thing, there is some judgments, landmark judgments. Ashok Kumar Thakur versus Union of India case 2008 upheld. See, it upheld the constitutional validity of Article 15, Clause 5. It overrides Article 19, Clause 1, Subclause G over Article 15, Clause 5. So Article 15, Clause 5 has more validity when it comes with conflict with Article 19, Clause 1, Subclause G. So now you should give state should make special provision reservation for SC, STs and OBCs advancement for their advancement and then Indian Medical Association versus Union of India case 2011 made a landmark changes, little corrections, upheld the Ashok Kumar Thakur versus Union of India case, but it particularly mentioned to private unaided non-minority educational institution, and now Article 15, Clause 5 is not for EWS reservation. So on minority institutions, see, by this minority institutions, Article 30, Clause 1 are exempted from this. So and Article 15, Clause 5 allows the state to legislate but does not mandate it without specific legislation. So now let us discuss. See, you want to know that Article 15, Clause 5, Article 19, Clause 1, Clause Subclause G, and this has conflict during the conversation with Supreme Court. Supreme Court upheld Article 15, Clause 5 in both the cases, Ashok Kumar Thakur versus Indian Medical Association case. That's all. This is the current affairs. See, but let us discuss some of the PYQs with respect to this current affairs and let us discuss model MCQs with respect to this current affairs. Okay, see. Statement number 1, 2019. The Constitution of India explicitly mentions the reservation in educational institution can be provided for scheduled caste, scheduled tribes, and other backward classes. So this is Article 15, Clause 5. Okay, statement 1 is correct. The Constitution of India explicitly mentions that reservation in private education can be provided for scheduled caste, scheduled tribes, and other backward classes. So this is also correct. Both statement 1 and statement 2 are correct. So it covered in 15 class 4. Sorry, it is covered in 15 class 5. Article 15 class 5. This is 15 class 4. This is 15 class 5. Now, 2012. So, which of the following statements are correct interpretation of right to freedom of profession under the Constitution? Right to freedom of profession under the Constitution. See, here it is absolute right. See, no, we just 19 class 1 subclass G mentions it has some reasonable restrictions also. So, it is subjected to reasonable restriction. Yes. So, see, 1 and 2 can't come together. So, now, automatically 1 is wrong, 2 and 3 is correct. It includes the right to run the educational institution. Yes. It is. So, see, the term minority education institution is mentioned which of the following? See, minority education institution is mentioned in Article 29 and 30. Article 29 and 30. This is 2017 PYQ. Now 2006. So which constitutional amendment reservation in private? See, which constitutional amendment enables the reservation in private education institution? That is 93rd constitutional amendment. 93rd constitutional amendment. So let us discuss some of the model MCQs with respect to this about topic. See, consider the following statement regarding reservation of SC, STs and OBCs in private education institution. The state empowers to make special provisions for advancement of socially and educationally backward classes in all education institutions, including minorities. See, in all education institutions, this makes the statement crucial. See, the state empowered to make special provision for advancement of social and educationally backward classes. Yes, that is correct. But here, whether it is mentioned for all education institutions or whether it is mentioned for all education institution or any other particular minority education institution. See, it refers to minority educational institutions. So statement 1 is wrong. Article 15 clause 5, which enables reservation in private institutions. Reservation was inserted into the constitution via 93rd Constitutional Amendment Act. Yes. Article 15 clause 5, it enables the reservation in private institution also. This was done by 93rd Constitutional Amendment Act. Okay, statement 2 is correct. So the Supreme Court of Ashok Kumar Thakur case explicitly struck down the validity of reservation in private unaided institution. Statement 3 is wrong. It upheld the validity of reservation in private unaided institution. So Article 15 clause 5 acts as enabling provision that overrides right to carry or on any occupation under Article 19 clause 1 subclass G. See, statement 4 is correct. I always said Article 15 clause 5 comes conflict with Article 19 clause 1 subclass G, but Article 15 clause 5 is overridden. Article 19 clause 1 subclass G is overridden by Article 15 clause 5. So it enables the provision to overrides the right to carry on any occupation under. Yes. So here only two statements are correct. Here only two statements are correct. Article 15 clause 5 specially excludes the minority education institution referred in Article 13 clause 1. So the state cannot mandate the reservation for SC, ST, OBCs in the institution for administered by minorities. You can't state can't mandate the reservation for SC, ST, OBCs in minority administered institutions. So now 93rd Constitutional Amendment Act added clause 5 for Article 15. So it legislatives this was legislative response to PA Inamdar case, where Supreme Court had previously ruled that state cannot impose its reservation policy on unaided private college. It cannot impose the reservation policy on unaided private college. Here statement 2 talks about. So which enables the reservation in private institution, which inserted into the constitution via 93rd Constitutional Amendment Act. Now, statement 3 is incorrect. In Ashok Kumar Thakur versus Union of India case, the Supreme Court upheld the validity of Article 15 Clause 5 regarding state unaided institutions. So, statement 4, 15 Clause 5, the special provisions operates now withstand the Article 19 Clause 1 subclause G. Yes, this is also correct. So, here, social justice, term combination social justice. See, this is how we discuss the questions. We had made a PYQ discussions with respect to this article. So, and model MCQ discussion. So now let us move to the next article. So next article is yes, this we discussed. See, this I had discussed explicitly in a separate video. So India experience with the transgender rights, and now we can move to, yes, this also discussed in separate video. Yes, now we can move for Supreme Court ruling in live-in relationship. See, live-in relationship. See, now, see, right to marry. Right to marry. So this is a classical case. See, first of all, here Supreme Court ruling in live-in relationship. So see, the marriage has been evolved. The marriage has been evolved. So now it has mostly up to the live-in relationship. So first of all, why this discussion came into the table of Supreme Court? A man accused of false promise of marriage after engaging in live-in relationship for years. See, now a man allegation of false promises. Man accuses for false promise of marriage after long-term living relationship. Now this case comes to the Supreme Court, because how the Supreme Court takes it comes under Article 21. So earlier, right to marry was under Article 21. This was asked in PYQ. Now, this has a potential to repeat the same question with a term of live-in relationship, or with similar modifications. That also comes under right to life. So, right to life. See, the judgment, what the judgment said. The judgment is gave a proper definition. If a two adults, if a two adults reside together for years in relationship, presumed volunteer with known consequences. They know their future consequences. If they start to live in together, that means live in couple, as a live in couple, they know their future consequences. And allegation for false promises become unintentable such prolonged volunteers in live-ins. Now, now unsecured false promises claim. Allegation unintended prolonged cohabitation relationship, focus shifted to consenship to shared understanding. Now, SC in Supreme Court interprets this live-in relationship recognized as part of individual autonomy under Article 21, right to life and personal liberty. Right to life and personal liberty. Now the Supreme Court has compared this with constitutional basis Article 21. Now Supreme Court interprets and recognizes live-in relationship as a individual autonomy under Article 21. See, my point is very clear. Right to marriages comes under Article 21. Live-in relationship also comes under Article 21. So now the Supreme Court is comparing this with Protection of Women from Domestic Violence Act, Section 2F. Section 2F recognizes the relationship in nature of marriage, offers legal remedies against domestic violence for women. Now, CRPC was Section 125, maintenance right extended to women in live-in relationship. See, this is a classical landmark judgment. They extended their maintenance right to live-in relationship also. Now marriage is not the only criteria, not the only criteria to make the maintenance rights. Live-in relationship also plays the major role. Chanmukhya versus VKS Kushawa case. Supreme Court upheld maintenance rights for live-in partners, affirming statutory protection. And now here the issue is between false claim and prolonged volunteer. Now this comes under the Supreme Court's note. Supreme Court's note. Okay. Now, live-in relationship, no overall conflict with marriage. See, it does not. So now this case, Criminal Procedure Code 1973 says that specific statutory provisions granted without declaring its legal equivalent to traditional marriage. See, they are not comparing it completely with this marriage, but they are referring it with Article 21. Article 21. Okay. So let us continue. Okay. This Article 21, Article Supreme Court interpretation, Protection of Women from Domestic Violence Act, Criminal Procedure Code. So key judgment point: if the two adults reside together as a living couple for more than a couple of years or cohabited, it can be presumed that their relationship was volunteer and both the parties are fully aware of its consequences. Allegation of false marriage to the marriage becomes untenable in such prolonged volunteer live-ins. Now, see, which of the now let us see the PYQs. Which of the Constitution India safeguards one's right to marry one's choice? Article 21, 2019 prelims. So see, now the same question can be rephrased and made as live-in relationship also comes under 2000. Sorry, Article 21. With reference to legal status of live-in relationship in India, consider the following statement. Consider the following statement. Okay, they right to choose. See, read it very clear. The right to choose partner and live with them is fundamental right protected under Article 21. See, right to choose the partner. Here the keyword is right to choose the partner. Yes, statement 1 is correct. The protection of women from domestic violence tax excludes live-in relationship. See, nowhere, nowhere it excludes the live-in relationship. So statement 2 is wrong. Long-term cohabitation between two consenting adults creates presumption of marriage-like relationship regarding maintenance right. Yes. The Supreme Court has ruled that false promises of marriage charges always maintainable regardless of duration in living relationship. No. The Supreme Court has clearly mentioned the time constraints, time constraints of living relationship. So here, regardless of duration is wrong. So once the statement 2 is wrong, 1 and 3 you come 1 and 3 gets correct. Okay. So the court presumes that both the party are aware of natural consensual relationship. Okay, but they have to be in a considerable time, not that any time like that. Okay, now let us go with Ladakh and demand for the sixth schedule. Ladakh and demand for the sixth schedule. See, it's very important, very important. Ladakh, because this has been in the news for past 2 years. Okay, now Union Government on June 3rd, 2025 notifies new reservation policies. New reservation policies. See, they just notified the new reservation. Why it is in the news? They just notified the new reservation policies and languages and domiciles and composition of Hill Council of Ladakh. Okay, so they are making new legislations with respect to the Ladakh. Okay, now Ladakh comes under which schedule, and let us discuss what are the important points. Okay, now for other residents, see here, Union government bifurcates. You know that August 2019, Jammu and Kashmir has been bifurcated. Union territory of Jammu and Kashmir with the legislature, Union territory of Ladakh without legislature. So weeks after that, National Council for ST took so moto cognizance for demanding Ladakh inclusion in sixth schedule. See, sixth schedule. That means National Commission for ST. They are asking for sixth schedule status for Ladakh. Okay, now the protest also has been. See, after 2019, there was a big protest with respect to add statehood of Ladakh to give statehood of Ladakh. So also inclusion of Ladakh in sixth schedule and job reservation for locals and separate parliamentary seat for Leh and Kargil. See, these and all we don't need these things. See, we need what are all the important ones with respect to the prelims. Okay, so first of all, National Commission for Scheduled Tribes. This we must know. We must know about National Commission for Scheduled Tribes, and the Ladakh is demanding for statehood also, and they are asking for sixth schedule status also. This thing we want to know. And what is the things in sixth schedule? What are all the advantages in sixth schedule? These are all the things we should know. Okay. So, and also domicile versus citizenship. The major concept is between domicile versus citizenship. See, domicile is something which is different from citizenship. Let us discuss all these things and all. See, first of all, domicile criteria. So there are new criteria for to give domicile status to the states. Before that, see, this all these things revolve around the reservation concept. Reservation concept. See, in Meghalaya, 85% of jobs are reserved to SC/STs. In Meghalaya, see, let us have a clear discussion. 85% of in Meghalaya is reserved to SC and STs. Okay, and Arunachal Pradesh, 80% of jobs given for STs. And see, this breaks the constitutional mandate of capping the reservation up to 50%. But but to develop the people, those who are residing in this area, this criteria has been followed. Now the domicile criteria. What is the domicile criteria? See, the Ladakh Civil Service Decentralization Recruitment Regulation was notified. First of all, see, these things and all is not required for prelims. So just know the story. Ladakh Civil Service Decentralization Recruitment Act regulation was notified. According to this, the job has been reserved for permanent resident of the state. So now the permanent residence comes into the scene. So this how who can notify the permanent residence? Tahsildar. How what are all the eligibilities? See, Tahsildar can notify. Tahsildar empowers to give notification, sorry, to give confirmation about residence of Ladakh. Okay. Now, what are all the eligibilities? 15 years. 15 years of residence in the UT from 2019. This is the first criteria. Second criteria, studied 7 years there and appeared class 10th and 12th in exams in Ladakh board. So, and also third criteria is children of government officials, all India services, and public state government services. So these are all the eligibilities to apply for domicile status. Now, and also there has been some of the changes, some of the criteria for hill council composition. So Ladakh Autonomous Hill Development Council. See, these and all, just you hear this. See, these are not required for UPSC prelims. Ladakh Ladakh Autonomous Hill Council. So they say that the reservation must be allotted for 1/3 reservation must be given for the Ladakh people, and also to protect the under the sixth schedule to protect the languages, all these things and all. Now domicile. What is meant by domicile? Domicile is something a legal concept. Legal concept refers to person of permanent home or as a permanent residence of the particular area. That's all. See, there is a difference between domicile and citizenship. There's a difference between domicile and citizenship. Okay. So now let us discuss PYQs with respect to sixth schedule. The area under sixth schedule. See, now let us discuss the PYQs. Then only you can come to know how the question can be framed from this above current affairs content. The areas under the sixth schedule of Assam, Meghalaya, Tripura, Mizoram are called autonomous district. Are called, yes. The autonomous districts have their own elected legislative court. Yes, both 1 and 2 are correct. So 2012, which are the following provisions of Constitution of bearing the education? So see, just without the following provisions of Constitution of India having bearing the education in sixth schedule. Answer is to be sixth schedule. Okay, 2020. With reference to administration of scheduled area and tribal areas, the fifth schedule of the Constitution deals with scheduled areas in several states. And the sixth schedule of area deals with tribal area in Northeast. Yes, these two are correct. Very simple. In 2020 itself, they asked very simple question. So Autonomous District Council in 2019. Autonomous District Council of 6th Schedule power, have power related to land, forest, marriage and social customs. See, these are all very important thing. Important thing. Now 2016, 6th Schedule. See, 6th Schedule again. Constitution autonomous. Which of the following is featured in 6th Schedule? Constitution of Autonomous District Council. Power to make law of specific subject. Power to collect land revenue. See, these are all with respect to Ladakh, that means 6th schedule status. UPSC is asking same question repeatedly. See, same question repeatedly. Same statement also. Now let us have a discussion of one model MCQs with respect to this statement. Okay. Polity. With reference to Union Territory of Ladakh, Reservation Amendment Regulation 2025, new domicile policies. The total percentage of reservation of government jobs in Ladakh, including economical weaker section, is now capable up to 85%. See, the economical weaker section is the keyword. They didn't mention about economical weaker section. So once you remove 1, 2, 3 and 4 are correct. The person eligible for domicile status if they have resided in UTs for a period of 15 years, started from October, yes, 15 years, 2019. The Ladakh Autonomous District Council regulations 2025 mandates 33% of reservation for women's. See, 33% of reservation for women's. Yes, this is correct. Bhoti and Pugri have been recognized as official language in Union Territory of Ladakh under the new regulations. Yes. See, Bhoti and Purgi. These are official languages of Ladakh Union Territory. So statement 1 is wrong. Union Territory of Ladakh reservation, yes, the total reservation shall not exceed 85%, but this specifically excludes EWS. Excludes EWS. Excludes EWS. Excludes EWS. Now, so I had discussed in detailed manner. We had made a discussion digital census 2027 delimitation. And also we had made an exhaustive discussion over this euthanasia, and this also. All these links I will be attaching in the comment section. And decoding the national anthem. Let us discuss the decoding the national anthem controversy in next video. Keep supporting, keep following. I'm damn sure that you will get a question from this area. Thank you.